Ladies and gentlemen, it is my great pleasure to participate today in this panel, and I'm very honored and very grateful to Paolo and Felipe for inviting me to take part in my capacity as President-elect for 2022 of the Consultative Council of European Judges. My statement will first describe the interpretation of Article 6, European Convention. Subsequently, I will focus on the work of the Ccje and describe the influence of Ccje regarding the case law of the European Court of Human Rights. Europe, as constituted by the membership in the Council of Europe, consists of 47 member states. This Europe, larger than the EU, has a broader cultural, legal, geographical and language dimension. And what is important? The Council of Europe has several members in which the erosion of the rule of law and of judicial independence is at stake. However, based on the Convention, the member states represent a legal community with more similarities than differences. Article 6 of the Convention states that everyone has the right to an independent and impartial tribunal established by law. The member states of the Council of Europe have accepted the obligation to guarantee an independent and impartial judiciary by national law. This obligation is legally binding for each member state under international law. Today, it is very important to make this clear, as some member states deny this obligation. The principle in Article 6 are institutional guarantees on which the rule of law depend. A functioning independent judicial system is therefore vital to the strengthening of the rule of law. An efficient, impartial and independent judiciary is the cornerstone of any functioning system of democratic checks and balances. What does an independent and impartial tribunal by law mean according to Article 6? What are the criteria, standards on the court's case law in more detail? And how do national judges influence the creation of these standards? The court has adopted a variety of important judgments related to the requirement of what a tribunal and an independent and impartial judiciary in general is. In this context, the court applies the principle of autonomous interpretation. This means that some of the Convention's key terms are to be defined by the court itself and independently of how they may be understood by member states. This interpretation relies on a systematic approach to the Convention, its goals and the common or divergent application of principles in the legal systems of its member states. Employing this value-oriented fact-finding approach, the court often defines common denominators or common European legal standard, which then are applied in the court's cases. The Consultative Council of European Judges is an important source in development of this European legal standard. Please allow me to present the Ccje and its work. Ccje is an advisory body of the Council of Europe. Its work is defined in the context of the implementation of Article 6, in particular, the right to an independent and impartial court. It is the only body within an international organization to be composed exclusively of judges, and in this respect, it is unique in Europe. It was created 20 years ago. The Ccje gives advice to the Committee of Ministers on issues relating to the status of judges and the exercise of their duties. All member states in the Council of Europe are represented in the Ccje. Every member state appoints a serving judge with an in-depth knowledge of questions relating to the functioning of the judicial system, combined with a high level of personal integrity. They members of the Ccje act in their personal capacity without any binding vote. With its work, the Ccje specifies the requirements for judicial independence. It provides an institutional framework for determining judicial independence. In other words, European national judges themselves specify thus and defend the European rule of law. The work of the Ccje is essentially characterized by two focal points, which may be described as benchmarking and monitoring. Benchmarking. Every year the plenary of the Ccje adopts opinions. They define the premises for judicial independence and impartiality, thus establishing a European standard. In addition, the Magna Carta of 22, adopted on the occasion of the 10th anniversary of the Ccje, there are already 24 opinions. Magna Carta and opinions are not legally binding. However, as they become part of the reasoning of the court's case law, they have to be considered as factual law. The Magna Carta enumerates the guarantees of judicial independence, referring to independence itself, the body in charge of guaranteeing independence, the access to justice and transparency, ethics and responsibility. It also states that the principles shall apply to judges of all European and international courts. The opinions deal with different topics. One focus is on the nature of the judicial decision-making process, such as the framework conditions of judicial activity, such as working conditions, tenure, training, performance, evaluation, remuneration, education, judicial ethics, but also with the quality of judicial decisions themselves. Another focus is on the relationship to other state authorities or judicial bodies. The representatives of the member states always endeavor to ensure that their opinions do not merely reflect a summary of their own legal cultures. When adopting the opinions, the plenary strives to determine a European standard. This does not necessarily reflect always the legal reality of each individual member state. In sometimes long and intensive discussions, the plenary struggles to find the best possible wording that meets this standard. It also considers the need to ensure coherence among the opinions. The plenary of the Ccje selects the respective topics of the opinion in an autonomous manner. The members formulate the requirements for the content of judicial independence. Their adoption is preceded by empirical findings supported by an expert on the situation in the individual member states. An overview of the respective national legal and factual basis obtained within the framework of these findings enables a partly descriptive, partly program-like presentation of the topic. Thus, the opinions are based on empirics and legal dogmatic. They conclude with a summary and recommendations that form a European overarching standard. National legislators and administrations may orient themselves to the standard, but also the court in its interpretation of the Convention uses the opinions as a source of law. Given the independence and competence of the members of the Ccje, the opinions have a high degree of legitimacy. And there's no doubt that the dialogue between the member states, which took place during the drafting of the opinion, already promotes the European legal culture. Thus, this creates a possible basis for legal standardization. Experience reports and statements of the representatives of the member states create mutual understanding for processes under the rule of law and make clear the concrete personal concerns of the judges, the requirements and challenges of the judiciary under the specific political framework conditions. In addition, the The task of the Ccje is to provide targeted cooperation at the request of the Ccje members, judicial bodies, or relevant associations of judges, and to enable member states to comply with the Council of Europe state standards. Attacks on judicial independence can come from both the executive and legislative branches. The Ccje deals with serious legislative infringements on the rule of law and comments on individual cases of violation of judicial independence. Overall, this activity may be described as monitoring. The reporting of violations of the Ccje reflects how fragile the rule of law systems are in some countries. Changes in the retirement age of judges, replacements and dismissals of judges for so-called incompetence, non-transparent appointment procedures, incomplete composition, or the creation of new courts are regularly reported violations of judicial independence. However, interventions in the economic basis or the organizational independence initially granted by judicial administrations should also be mentioned here. Moreover, politicized media coverage, populism and general political encroachment put judges under pressure and indirectly influence judicial decisions. The reports clearly show that by addressing the Ccje and by its monitoring opinion, certain timely publicity can be achieved. It thereby partly fends off the attacks on judicial independence or keeps them within limits. The fact that in general the respective states take the report seriously is shown by the fact that they, for their part, can comment and explain themselves and sometimes do so very explicitly for all further reactions under European law and policy. As follows, please let me describe the influence of Ccje on the case law of the court. The court regularly and increasingly refers to the statements Magna Carta and opinions as source of a European standard for the requirements of judicial independence and impartiality. It is recognized that the work of the Ccje builds the basis for the development of the relevant international standards for measuring independence and impartiality. The court refers to the opinions literally in the facts as, I quote, relevant domestic and international law or documents. Thereby, the Ccje is integrated into the case law as European standard as a source of soft law. And I quote in so far the concurring opinion of former judge at the court, Paulo Pinto de Albuquerque, in Baca versus Hungary. You remember the facts we have been told this morning. The court's direct recourse to international law standards on judicial independence, including soft law sources as a source of law in order to address the applicant's situation, is highly remarkable and laudable. The court invokes the soft law of the Council of Europe as a legal basis, not only to sustain the principle of the independence of the judiciary in abstracto, but also to assert in concreto the existence of the applicant's individual civil right to irremovability and of access to a court to protect that right in the Hungarian legal framework. End of quote. In the case Baca versus Hungary, the focus has been particularly on the issue of the tenure and removal of judges by the executive and legislative powers. Up to now, this has been one of the main reasons why the court stated a violation of Article 6. The court referred in its reasoning substantially to the opinion of the Ccje as source of law and remarks as follows. Explicitly, the court argued Ccje considered in Opinion 1 already that the removability of judges should be an express element of the independence enshrined at the highest internal level, that the intervention of an independent authority with procedures guaranteeing the full rights of defense is of particular importance in matters of discipline, and that it would be useful to prepare standards defining not just the conduct of may lead to removal from office, but also all conduct which may lead to any disciplinary steps or change of status, including, for example, a move to a different court or area. End of quote. The court as well quotes the Magna Carta of judges. And as it is so important, let me quote this as well. Here we say, judicial independence shall be statutory, functional, and financial. It shall be guaranteed with regard to the other powers of the state, to those seeking justice, other judges, and society in general, by means of national rules at the highest level. The state and each judge are responsible for promoting and protecting judicial independence. Judicial independence shall be guaranteed in respect of judicial activities and in particular in respect for recruitment, nomination until the age of retirement, promotions, immovability, training, judicial immunity, discipline, remuneration and financing of the judiciary. And in the guarantees of the opinions, it is said that the judiciary shall be involved in all decisions which affect the practice of the judicial functions. This brings us to the question which individual source of law in the Ccje carries the most significance. In particular, the court refers to the Magna Carta. However, other opinions are also explicitly referred to as a source of law. This includes opinions concerning the qualification and evaluation of judges, as they are opinion on standards concerning the independence of the judiciary and the immovability of judges, or on ethics and liability of judges, or on the quality of judicial decisions. Finally, the opinions which concern the relationship of the judiciary within the society, as they are, for example, the opinion on the position of the judiciary and its relation with the other powers of state in a modern democracy. Today, it is important to mention that in the context of the recent decisions on the rule of law, mainly in the case law regarding the situation in Poland, the Opinion 10 on Counsel for the Judiciary at the Service of Society has gained particularly importance. The court refers in some cases not only to the Opinion 10, but as well to the statement of the Ccje Bureau following the request of the Polish National Council of the Judiciary to provide an opinion with respect to the draft act of September 2017 on the Polish National Council of the Judiciary. The Bureau of the Ccje represents the Ccje. And in the case of Poland, there have been several opinions of the Bureau stating that drafts on the selection methods for judge members of the National Council, pre-term removal of judges, the structure of the National Council would infringe judicial independence insofar as the legislative and executive powers will have a decisive role in the procedure for appointing judges. Expressively, the Bureau assessed the adoption of these acts as a major setback for the rule of law and for judicial independence. In reaction to the occurred situation in Poland and other member states during the last years, the CCJE decided on the new subject of the opinion for this year, for 2021. Referring to the old opinion 10, CCJE followed up these general recommendations on the composition, functioning and powers of the Council of the Judiciary and developed its standards in the new opinion 24 on evolution of councils for the judiciary. It can be assumed that this opinion will also be considered in the case law of the court. Here are the major conclusions and recommendations. The members of the Council must be selected in a transparent procedure that supports the independent and effective functioning of the Council and the judiciary and avoids any perception of political influence, self-interest, or cronyism. The majority of members of the Council should be judges elected by their peers, guaranteeing the widest possible representation of courts and instances, as well as diversity of gender and regions. A selection of judge members by Parliament or the executive must be avoided. Members should be appointed for fixed time in office and must enjoy adequate protection for their impartiality and independence from internal and external pressure. A member's term should in principle only end upon the lawful election of a successor. The CCJE wishes to reaffirm the importance of security of tenure of all council members as a crucial precondition for the independence of the council. Members may only be removed from office based on proven serious misconduct in a procedure in which their rights to a fair trial are guaranteed. Let me please conclude my statement with 2 points. First, the case law of the court relies increasingly on the work of the CCJE as a relevant source of law in interpreting Article 6. Therefore, the case law of the court reinforces the factual lead to binding quality. Thus, I would like to encourage the court to rely on the work of the CCJE in the future as well. It may strengthen the legitimacy of the court's judgments. And secondly, although we observe critical situations for the rule of law in some member states in Europe, we have to take into account that within the Council of Europe, all member states share a broad legal framework of common values. Let me emphasize that we have more similarities than differences. In a huge amount of member states, the legal framework of the judiciary fulfills the requirements of the CCJE opinions. This presents a basis for further discussions and solutions for the benefit of the rule of law. We have to listen and to communicate with each other. Therefore, bodies as the CCJE are very important. It is crucial for the rule of law to strengthen the legitimacy of the European standard. Insofar, CCJE plays an important role. The CCJ is a platform for all members to indicate infringements of the Convention, but it also offers as well the possibility to those member states who are in the focus of the violation to explain their opinions and positions. Therefore, I would like to encourage all member states to participate actively in the CCJE's work and to communicate its work to their judiciary as well as to their legal and executive powers. The CCJE rely on the support, input and cooperation of each member state. We together create the European legal standard for the judiciary and present a unique element of European legal culture. Thank you very much.